This is Constitutional Rights in Black and White. As we have now seen, municipal courts play an essential role in local government and local justice. That localism is a double-edged sword. It creates problems with resources, with political accountability, and with inequality. And at the same time, that same localism creates opportunities for engagement and for change. As Justice Louis Brandeis wrote nearly 100 years ago, in our federalist governance arrangement, a state or local government can, if it chooses, serve as a laboratory. And change is happening. Municipal court judges, city offices, nonprofits, advocates, community leaders are all experimenting with all sorts of policies and programs in an effort to improve and strengthen their municipal courts. This video presents examples from all over the country. Previous videos in this series showcase additional experiments, and there are many more out there. There's no one model, no one solution, and plenty of disagreement. Nevertheless, these examples offer valuable insight into the kinds of work and change taking place on the ground in American cities large and small. The following footage was taken from the last 2 webinars in the Municipal Court webinar series.
Our Supreme Court has absolutely defined courts of limited jurisdiction as courts of rehabilitation, not retribution.
And I just sat there and thought, I just don't know how this is justice.
We want to emphasize, if you're going to start a program like this, you want to try to be as inclusive and low barrier as possible.
As you can imagine, there are endless opportunities to get creative and often to partner with community organizations.
Talk to everybody. Police, prosecutors, community members, faith-based, talk to everybody, especially the ones that you think don't want to help.
And all we did was say, if community creates court for itself, what would it look like?
My name is Aaliyah Sabri. I am Chief Judge Pro Tem at 36th District Court here in Detroit. And I'm here to speak about the importance of Detroit Warrant Clinic. Today, we are here at Butzel Recreation Center. This is our 3rd warrant clinic. And I want to speak on the importance of continuing this partnership with different organizations, especially our own Wall Street, to bring people out to take care of their warrants for traffic matters. So I've been at the court for 8 years. And when I'm in the community, people are always speaking of how they are in fear of being arrested and how they don't trust or have good relationships with the judicial system. So what we decided to do was come out into the community and provide resources as well. We have the Secretary of State here and other resources to help people to get their matters in order. Because what we have seen is that when people can take care of their warrants, get a court date, have clear understanding of what they should be doing next, they can get their license back, which means they won't be in fear of getting arrested or getting, their job taken away from them, children, or going to jail, Wayne County Jail, for small matters such as a traffic warrant.
10 years ago in Toledo Municipal Court, we created a procedural fairness training program that included everyone who works in our building, from the judges to the cleaning crew. The judges, by the way, I think you'll all agree with this, were the hardest to get to the training. And the judges who don't need procedural fairness training are the first to sign up, and the ones who really need it refuse to go. We believe procedural fairness is so powerful that with the help of the Center for Justice Innovation, we created a 3.5-hour diversion curriculum for persistent offenders based on procedural fairness. Over 8 years, we've had 3,000 people attend the program with a 64% successful completion rate. We have done surveys over these 8 years with all 3,000 people. 94% of the participants in this diversion program said they learned at least one new coping skill. Think about that. 94% said they learned a coping skill from our diversion program. 81% said they gained a new perspective on criminal justice. Their perspective on criminal justice is cops are unfair. They now have a new perspective. 97% even said they would recommend the class to others. What all that means is their next interaction with the police from this group of persistent offenders is going to be different and less likely to result in their arrest. We believe this program is improving individual outcomes and increasing public safety and trust. The Access to Justice Lab at Harvard Law School has started a rigorous randomized control study of our curriculum, and in a few years, at the conclusion of the study, we hope to add our diversion program to the list of best practices under procedural fairness.
So heading up to the public defender component of this, or just making sure that there is an attorney available from the very most critical first stages, like first appearance, for example. But having a trained attorney, as we know, makes a significant difference, not just in preserving the rights of the individual that's coming before the court, but the fact that you as a judge are making sure that that individual's rights are being protected is really enhances the trust component of what you can take on as your role as a judge. It provides some confidence that you really are there to preserve justice and not just rubber stamp decisions that are coming in, or that you are subject to special interests in any way, shape, or form. So there's a number of reasons to do it, besides the very most important constitutional right to be represented by an attorney.
So some of the key features of our programming that makes it really flexible is a private-public partnership with the court. So we are in the courts, but we are not of the courts. This is something that we try to emphasize, especially when we're working with our clients, because that is always a concern. But as a private organization, we have flexibility where we can be adaptive to the community's needs while we're working with the courts and helping them resolve these matters. The way that we do this is in the first picture, you'll see we're in the court. We're physically in the court. We're helping clients. We're taking them through the process and working with court staff to help people go through that process. We also have community pop-ups. We are at local libraries and, for example, a homeless respite center that is in our area. And we will bring laptops and we will work with the locations who have computer centers so that people who don't normally have access to virtual court are able to attend court virtually and be compliant with their mandates. At this time, the Newark Municipal Court is still virtual, so this is still something that we are doing, but of course, this started during the pandemic.
The final thing I want to talk about is that requiring people to come to the courthouse is particularly problematic for people who are unhoused. It means they have to abandon their few possessions and their pets, which they frequently have to come to court, so they often don't. So one of the things you could consider is creating an alternative location. So this picture is actually Boulder's Community Court. The person in the front in the blue shirt is one of the court navigators. The person in the front in the green shirt is one of the prosecutors, and across from her is one of the clients. And what you see going on in the background is the clothing closet, which is run by a local church, but is housed at the city's municipal building. And it's outside year-round. Pretty much rain or shine. Only really cold weather is going to cause the event to be canceled because it's of danger if it's dangerously cold. But this is a place where people who are unhoused are gathering anyway. They're getting new clothes. They're getting usually a cup of coffee and a granola bar. So this was a logical place for us to choose to set up the community court. And then finally, if you'll go to the next slide, I'm going to hand this back to Judge Logan because Spokane also has an amazing community court, and we took many of their concepts when we stood up ours in 2020.
Thank you, Judge Cook. Yes, this is my heart, I have to admit. The researchers in this field who have no bone to pick other than just an evaluation have told us time and time again that continuous and constant jail is only going to result in continuance and constant jail for a person. That the terms and conditions that can be imposed that don't involve jail stand a much better chance of elevating someone out of the system and into a more healthy and healthful life, which is really what we're all about here.
All right, and then I'd like to talk a little bit now about the front end of a case where there's an opportunity for a diversion or dismissal. With diversion, cases are typically diverted from the criminal justice system entirely. So in Longmont, Colorado, for example, police divert juveniles to a restorative justice program in lieu of issuing them a criminal citation. So they never even enter the criminal justice system. There's no documentation of their shoplift, for instance. In Boulder, Colorado, the prosecutor dismisses low-level violations for the unhoused when they complete an alternative sanction. And that alternative sanction is beneficial to them, which means it's ultimately beneficial to the community. So examples are getting important documents such as IDs or social security cards. Those are needed for employment, for permanent supportive housing. So again, benefit to society. Other examples are working on housing, getting health care, or participating in mental health treatment.
And I'm here today to share about a program I developed to promote financial equity within a community supervision program. This model is built on the risk needs responsivity principle, which focuses on identifying criminogenic risk factors and tailoring responses that effectively address them. Drawing on this research, along with my background in mental health and behavioral change, I explored studies on fines and fees reform. Combining these insights, I designed a program that offered a compelling alternative to traditional payment-based penalties. Each approved activity would be assigned a monetary credit, essentially creating a system that rewards constructive behavior with financial relief. A fundamental principle of this program was that it had to be available to everyone, not just those who qualified based on financial need, because everyone under supervision could benefit from these kinds of positive activities, and we wanted the program to be inclusive and not stigmatizing. We also assigned different dollar values to activities based on two factors: the level of effort required and their intrinsic value in reducing recidivism. For example, completing a GED or a high school diploma, a major step in long-term success for clients without a degree, earns $100 of credit. Securing and maintaining employment, another critical factor in reducing reoffending, earns $50. And I'm going to pause here just a second and let you see the number of free activities that our folks completed. So I'll never forget, in the beginning of the incentives program, one of my staff came to me and she had just completed an intake with a man and he had broken down in tears when she explained how he could use the incentives program to help pay his fees. He had told her that during his previous probation, he had been forced to sell his blood plasma just to make his payments. And that moment made it painfully clear how meaningful and how overdue this kind of alternative was. What I didn't expect was the financial impact. In the first 2 years of the program, we saw nearly a 10% increase in revenue from community supervision fees compared to the 3 years prior, when the incentives program didn't exist. Even more significantly, we achieved this without sending anyone to collections and with very few cases comparatively being returned to court for failure to pay.
One time, and it's your boy Sing Music, man. It's a great day in Pontiac, man. It's the Warren Clinic. That's right. Shout out to everybody that came outside to take care of business.
In partnership with the national nonprofit Black Voters Matter, Anza Becknell, the founder of Growing Real Alternatives Everywhere, or GRAY, works with local judges and community grassroots organizations to run weekend warrant clinics. Held in the community, the clinic's atmosphere is far removed from the traditional courtroom. There is a DJ, food, and limited police presence. There's also childcare and transportation for those who need it.
Even holding court on a Saturday gives a lot of folks more opportunity to do what they actually want to do, and that is take care of their matters and be productive citizens.
Hello, hi.
But for Alan, the main draw was written right on the poster: no fear of arrest.
You keeping your mom company?
people are understanding this is not a sting operation. We are really lifting these warrants so that people can be out there legally. Part of it is just building back trust.
Alan and her daughters appeared before a plainclothes judge, Cynthia Walker.
Most courtrooms have the judge sitting a little bit higher, and I think there's more of a feeling of connection with the person sitting across from you. Tell me what your names are. Kadarie? Callie. Okay, glad to have you here.
Thank you.
Normally, children are more of a distraction to the parent, so we encourage them not to bring their children. But the whole feel of this today, there was a young woman who had her 2 daughters with her, and she said she wanted them to see the process. It's an educational opportunity. I want them to know that where I'm sitting, they can be. I may be a judge, but I'm a person just like them.
The concept here is that juxtaposition, sometimes that conflict between municipal courts and the politics in which the court sits and the pressures that may be placed upon the judge to make money for the entity in which they are sitting. And so it is important to always remember the neutrality in which we are supposed to operate. The courts of limited jurisdiction, municipal courts, are really known as courts of rehabilitation and not retribution. So it is leaning in on those principles and these principles of procedural due process and giving the voice neutrality, respect, and trust.
A lot of these programs are created by people who work in the justice system, and there's nothing wrong with that. But just to clarify, the Warrant Clinic is a court model created by the community. The Warrant Clinic was created by a group of community members who wanted to address an issue that they had in their own lives on their own terms. Meaning, here's the question. If the community created court, what would it look like?
Well, the City of Mobile decided to engage in this initiative because it's truly an opportunity to provide our citizens, our residents, with an opportunity to resolve traffic-related warrants in a non-intimidating and supportive way. So we thought and only saw fitting to partner with Gray in doing that, being able to come together and foster a sense of community while taking care of business. So it allows the court to help manage its docket while helping our citizens clear their record. We've actually had quite a bit of accomplishments through the traffic warrant clinic here in the city of Mobile. The primary thing is obviously been able to resolve hundreds of traffic warrants, and we're able to do so in a safe space that's welcoming. Also, the huge goal too is to improve public trust, especially since we're doing it in a non-intimidating way. And collaborating with Gray has helped us expand our reach and impact of the program. So it has been very successful, what I call a win-win situation for our residents as well as the court, the city of Mobile.
And in this last slide, I really just want to highlight some of the impact that we've had since 2011 when this community court began. First of all, there has been a huge decrease in the use of fines and short-term jail sentences for the community in Newark. Over 10,000 individuals have been diverted from traditional court processing, and over 1,400 of those individuals were referred exclusively for failing to pay fines and fees. It increased the use of social services and community service. We have on-site access in the courthouse to behavioral health, job readiness, and trauma-informed social services. And over the years, 107,839 hours of community service were completed. There's also an increase in compliance and accountability for court mandates. Over 90% of our participants have completed the initial intake, and close to 75% of individuals successfully completed the program. So they avoided those fines, fees, and incarceration. So a pretty high rate of compliance.
These are more than just completed tasks. They are life-changing milestones, and they demonstrate the true power of providing opportunity over punishment.
I would just say Talk to everybody in your community. Keep open lines of communication, especially with the police and the prosecutors and the public defenders. Keep that open communication. See where there's common interests, where you can have common wins.
Well, that's the end of our series. I hope these conversations illuminated for you the importance of municipal courts for our criminal system, for our legal system, for city governance, and for our democracy. If you'd like to learn more, take a look at the Municipal Courts Project at www.municipalcourts.org.